Hello everybody and welcome to our Think House Spring session on data privacy. I'm David Lowe, I'm one of the leaders of our Think House programme. Think House is our programme aimed at in-house lawyers looking to help you support you in your practice. And Think House Spring is our programme of events. We started with employment on Tuesday, we have data privacy today, customs and trade on Tuesday next week, and human rights on Thursday. Apologise now if there's a bit of background noise. My neighbour has decided just 5 minutes ago to decide to prune his trees. Please do bear with me. Thankfully, I won't be doing much of the talking today, so I'll be able to go on mute in a second. So we're going to be talking about data privacy today. We're going to therefore be joined by Jocelyn Paulley, who's an IT and data privacy partner, and Rocio de la Cruz, who is a senior lawyer in our data privacy team. Rocio is actually dual qualified, so she can bring both an English law and a Spanish law perspective to this, which is obviously particularly useful with data protection. This session will last for about an hour, maybe just under an hour, and finishing at 11:30. There'll be plenty of time for Q&A. We'll have 2 slots for Q&A because we're going to talk first about data sharing, and then second, we're going to talk about international transfers. And we're touching on those 2 issues because they're the issues that we're getting lots of queries on. They're complicated and people want to understand how that works. They're coming across them all the time. Between the 2, we'll focus more on data sharing because obviously that's relevant to anyone, while international transfers will be only relevant to those of you sort of trading internationally or having the international data transfers. I'm conscious, having heard the rehearsals, just how dense a subject data privacy is. So, there is a limit to what we can do in this 45 minutes. So if as you get to the end, you're sort of left want more, just let us know. Put in the Q&A or in the feedback forms. We're certainly very interested in doing more in-depth data privacy talks. Also at the end, there will be a little bit of a poll. We're just sort of trying to judge. Our next big event would normally be in September. And obviously our big decision is whether we do it like this remotely or whether maybe we can dip our toe in the water and do it for real. And obviously it's really difficult to tell right at the moment, but we're just wanting to get a sense of psychologically where people are. So at the end of the session, we'll be asking you a couple of questions about how up would you be for going to the office or whether actually you'd prefer to wait and see or sit it out and maybe it won't be until next year. So first, we're going to start with Jocelyn. Jocelyn's going to talk to us about data sharing.
Thanks, David. Good morning, everybody. So our first topic is indeed data sharing, and we're going to start with the deceptively simple question: how do I share data in a privacy compliant manner?
And this is something that we've got many questions from clients. What do you mean by sharing, and what do you mean by sharing data, isn't it?
Exactly. And that's one of the reasons we want to cover this topic now, because increasingly the work on our desks is about data sharing. I want to flag a terminology point first of all. We're seeing sharing being used to cover a wider and wider range of activities. So traditionally, what we would have thought of as fairly simple processing between a controller and a processor when you have a customer-supplier relationship, and then true sharing between both independent controllers and joint controllers. And this is getting increasingly complex as we see it being used in different areas, often with multi-party data sharing, if you're working in areas like public sector or life sciences or research or anything where there's technology at the heart. So in this session, we're going to look at, as David said, in a brief fashion to get through in the time we have, sharing between all those different sorts of parties. So sharing is a big topic, so we need to break it down into some more basic questions. And we've got 3 steps for you to help take you through that process. The first is around context. So when you're thinking about sharing, the first thing you need to do is the point I just touched on, work out the capacity in which each party is acting. How are you sharing data and what is your relationship? Because that's going to drive how you approach it and the requirements of a data sharing agreement. So are you a controller? Are you interacting with other processors, other controllers who are going to be independent? or other controllers who are going to be joint controllers alongside you. You always need to do a double check. Am I definitely sharing personal data? It's not actually anonymized, so I can step outside of the data protection regime altogether. And is it pseudonymized, which of course is good data protection practice to not share more data than you need to. But bear in mind, pseudonymized data is still personal data and is still subject to GDPR regulation. As part of that check, you're also challenging your business. Do we need to be sharing this as personal data? We can't strip it back further to share simply anonymized statistics or facts, and we can't pseudonymize either. We have to share this granular level of data so you understand exactly what's being shared and why. It's a good idea as part of the context as well to work out if this is going to be a one-off sharing or the start of a regular process. That's going to factor into your thinking about risks and approach and what you need as part of your documentation. You'll also want to know, is this a data sharing arrangement which is really about a data flow and passing data between parties, or is it actually linked to the provision of services? So that will impact your documentation, because you need to know whether when you're drafting your DSA, does it need to work with and alongside a services agreement, thinking about crossover points like issues around termination, liability, where do my audit rights and details sit, what am I saying about subcontracting and sub-processing, so to check that you don't treat those common issues differently across different agreements, but actually where it's all linked together. What those agreements look like is something we'll come on to look at as we go further on through the steps. But so your first step is really important to get the context so you understand what data you're going to share.
And the context has changed a lot, hasn't it? Because we moved and we are evolving in this context of data sharing and the roles, and the culture has changed as well. From the beginning, when years ago before GDPR, we were probably more focused on putting data processing clauses with just processor to a broader scope. As you are saying, now we need to focus on joint controllers. We need to understand what a joint controller is. We need to understand what data sharing is and whether or not the data sharing between independent controllers is relevant, and the responsibilities and so on. So we have much more broader discussions now, if you like, with clients. Whereas years ago it was just, this is a service provider, I'm going to assume it's a processor, and here is the standard clauses that apply to everyone. So it's completely different context now.
Yeah, that's absolutely what we're seeing. The context is becoming so much more complex as more data is available. Companies are becoming more sophisticated in how they want to use that data, looking for ways to innovate by making use of data that's available. So as Rocio says, that context is no longer a given, that it is a relatively simple services relationship. You have to drive behind, and often we find ourselves focusing on who is really deriving the benefit from these arrangements to work out who's acting in a controller capacity, because it is quite easy to now divorce people getting their hands dirty, if you like, and doing a lot of the operational processing and those involved in the decision making. So this fact finding and context, which we talk a lot about when we talk about data protection, so we talk about doing your data mapping early on in your GDPR compliance processes, it's so important to inform how you then analyze what you need to do and the risks involved. So once you've established that context, the next thing you need to do is then start applying the GDPR rules. So the first thing you want to be thinking about is, why is this data being shared, and therefore what is my legal ground for processing? We're all familiar with those grounds. You need to think about it for your ordinary personal data, and of course any special category data if you're going to be sharing that too. Bear in mind that if you're relying on legitimate interest, this is definitely a scenario where you ought to be doing a legitimate interest assessment test as well and recording that formally, particularly where you have multi-parties or you're doing something slightly unusual, to make sure that the benefit to the organisations really does outweigh any harms that might be caused to individuals, and to see how you might minimise those. I just mentioned documentation. So the other big question is, have you done a data protection impact assessment? And this is a question we get a lot, isn't it, Rocio, about how do I need to do this and how far do I need to go?
Yeah, and of course we've got the requirements where, and the GDPR, the data protection impacts assessment, is mandatory and you need to carry out with all the content that is expected. But on the other hand, sometimes we still carry out data protection impacts assessment, even if it is not mandatory, because it is really convenient to analyze the risks. And sometimes perhaps certain data is not classified as special category of data or criminal offense data, but it's still sensitive to the individuals. And so you need to analyze that. And it's very useful as well if in future you have unlikely events that there is a data breach, an unfortunate serious data breach. What you did consider before as part of a data protection impact assessment is very useful as well to help you to help clients to react on time and to know what to do, the steps that to take. So it's definitely really important. And but we use kind of different forms, don't we, just depending on whether it is mandatory or whether it is voluntary. Perhaps it's a shorter version.
Exactly, yes. That's definitely true. The way in which we use DPIAs has been evolving and is context specific. And this is something that we have been doing anyway, and it's now backed up by the ICO's Code of Practice, which came out last December, which focuses, well, the Code of Practice is all around data sharing, but the really strong direction and guidance to business coming out of that Code of Practice is to use DPIAs, not just in the situations where they're mandatory, as in GDPR, not just in the situations flagged by the EDPB's guidance, which we've had for more or less since GDPR came out. Actually, it was one of the really early guidances. They have about 9 criteria there, and say if your context hits a couple of those criteria, you ought to be doing a DPIA, because those are scenarios where the regulators consider you are likely to trigger the threshold of the processing, likely to cause a high risk to rights and freedoms of individuals. But the ICO's Code of Practice goes a step further and is saying, really, you ought to be doing a DPIA for any sort of data sharing, precisely because, as Rocio describes, it's a flexible risk assessment tool. So if you're doing something that's at the higher end of the scale, a major project, lots of data, doing unusual things, absolutely full on DPIA in detail. If you're somewhere further down that scale, then some form of DPIA where you gather together your data flows and do a little data map and understand how you're going to process that data in a privacy compliant way. That's what the regulators expect to see.
And there is no hesitation. Oh, sorry. I was just going to say there is no hesitation that it helps to demonstrate compliance with the accountability principle as well. So still useful in terms of Article 5 GDPR.
Exactly. And the ICO even goes as far as to say that even if you feel that you really don't need to do a DPIA, they still expect to see a piece of documentation somewhere that shows how you believe that this particular data sharing is GDPR compliant. So I think there is really no getting away from the fact that that documentation has to exist in one form or another. So the last thing you need to think about when you're running through your basic checks and applying your principles is there an international element to this data transfer? That's a question that Rocio will look at in more detail in the next part of the talk.
There is a question that someone flagged asking whether when we refer to GDPR right now as part of the session, whether we refer to European GDPR or UK GDPR. And I think that for the purposes of data sharing, there is no difference between UK GDPR and EU GDPR. So we refer to how it is implemented now in the UK.
Perfect. Yes. Thanks, Rocio. So once you've got your context, you've run through your basics and you're happy that you can share this particular data in a privacy compliant way, the third step is then to consider the data sharing agreement itself. The form that data sharing agreement takes will be driven significantly by the relationship between the different parties, whether you have joint controllers, separate controllers, or a controller and a processor. And Rocio, this area of joint controllers and data sharing is one in which we are seeing, I think, the greatest development and the greatest amount of focus at the moment.
Definitely. So probably because of recent last year's case law that have helped a lot to define and to see how the term joint controller is interpreted, which is really broad. Like we have, for example, the Jehovah's Witness case in which one of the parties in the community, it was not even seeing that data, and it was still considered that the parties were joint controllers. And because we see the developments as well on what is expected, how Article 26 arrangements, the level of detail, sorry, just having a little cold, the level of detail that needs to be incorporated there, assessing and really defining with a granular level the responsibilities between the parties. And we see different scenarios on that, don't we? Just because we have the simple joint controller where it is very clear that both parties are jointly taking decision on each particular thing. We see other scenarios in which one party is responsible for practically everything because it's the only party who has direct contact with data subjects. And then we see, we work on these complex research projects in which each party is individually collecting data, putting it together into another data set. And then there are different accesses, different purposes, unexpected or purposes that are not overseen at the beginning because perhaps they may be using artificial intelligence tools or machine learning tools. And therefore the Article 26 arrangements becomes, and the privacy notice as well, because there is an impact, becomes much more flexible, and you really need to keep it up to date. So it's completely different. So definitely a lot of evolution on this matter.
Yeah, I think there's a few reasons for that. One is, as you say, the case law and the guidance that we now have from the regulators on what they consider to be joint controllers. So as what we used to see as quite a narrow definition, it's clear now that they're interpreting that much more broadly, which has mean we've started talking about it a lot more with clients. It's something we need to consider because clearly the regulators believe it has broader application. But also I think because of just the prevalence of technology in today's life, there is now so much more data available that companies are looking to avail themselves of and work out how they can use that to their benefit, that it's increasingly an area of focus. And I think because an area of innovation, that's why you're getting multiple parties coming together. I've never looked at so many multi-party agreements as we have around data sharing, because it's where people are doing more research or innovation or setting up some kind of joint system to benefit multiple parties who get these kind of arrangements. So it's definitely an area in which we are seeing a lot of movement, and it's really significant from a data sharing point of view, because you need to, the contrast between whether you're dealing with joint controllers or separate controllers or controller processor will have a huge influence on how you draft your agreement. The only mandatory requirements around having joint controllers from a data sharing point of view is working out who's responsible for delivering the privacy notice to individuals and who is responsible for responding to subject rights requests. You do, though, also need to consider which party, and this is obviously more complex in a multi-party scenario, is going to handle each of the GDPR principles, who's going to be responsible for those. So that's what your data sharing agreement will set out. If you contrast that, though, to what you would have if you simply have simply have independent controllers acting for their own purposes. In that situation, there's no legal requirement to have any kind of data sharing agreement if you look in GDPR. So you're at liberty to decide what your documentation needs to say. And we see a range of possibilities here, depending on whether you are really two quite independent parties doing separate things. We might have very light touch clauses, or it is actually a customer-supplier relationship, but where the nature of the supplier's services and role, say, for example, like lawyers or accountants, means that they are actually independent controllers for some elements of what they do. And so your clauses might look more like a customer-supplier, controller processor type of clause with some areas lightened. And if you just pop the slide up, please, and then you can see the contrast at the other end. If you have controller processor clauses, obviously there we know exactly what's required. Article 28.3 has been around for some time now, and we're quite comfortable with the requirements of those clauses. We have seen them develop significantly, I think, over the last 3 years. So now we have a sort of very basic, repeating more or less what the legislation says, all the way along to much more developed clauses where you have suppliers offering standard services or customers dealing with huge volumes of data with a multitude of suppliers, and again want to have standard processes across their contracts. And your final piece to think about in terms of documentation is the international transfers piece, which again, we'll cover in the second part of the session. So on this next slide, I've put up a lot of practical considerations. These have come from the ICO's code of data sharing that I mentioned previously, and are all things that the ICO says ought to be captured in a data sharing arrangement. But if you look at this list, a lot of it looks very operational.
And there is a lot of clients asking us, why do we need to put all these operational things, making the agreement even longer, even much more detailed? Is this mandatory?
Indeed, that is the question that we get. And we think there's good reason for including all of this detail in those contracts. In any IT or services contract I look at, this is all the kind of thing I would expect to see in a service specification, setting out exactly what one party is going to deliver to the other. This is the equivalent in a data sharing world. There's also other legal advantages to having it in your agreements. If you're the recipient of data and you actually receive in reality more data than you were expecting, if you can point to a data sharing agreement that says, I was never meant to have this, it's actually another party that's at fault for giving it to me, you're then not at risk of any claims that you've obtained data where you shouldn't have done and have no lawful ground for processing it. It also has the advantages of clarity, so every party is very clear who is responsible for what element of GDPR compliance. And of course, you do need to know that for all of the controllers together to be compliant in a joint controller scenario. As Rocio was saying earlier, it would go towards accountability, shows you've done your thinking, been very clear and transparent in your arrangements, which is obviously at the heart of GDPR. It's also a convenient place to record things like your lawful ground for processing, particularly for public sector organisations where you're going to need to identify the particular piece of legislation that gives you the power to share data, just slightly separate consideration to what private companies need to be aware of and think about. So there are lots of advantages to putting all of this in a data sharing agreement. Clients also ask us, how far do I need to go? How much of this is really necessary? And that really comes back to your context. Is this a high risk situation? Are you doing unusual things? The more the answer to that is yes, the more detail ought to be included to show how you're being transparent and complying with GDPR principles. All of this. Sorry,
I was just saying, and in fact, in a data controller processor scenario, if we look at the standard contractual clauses, controller to processor, not for international transfer, in a controller processor scenario that have been considered or even approved by the European Commission, we see this level of, or we see clauses that are meant to deal with this level of granularity. So, and the European Commission, for example, when the Danish standard contractual clauses were being approved, they say that if you don't have it, and if you don't allow to this level of granularity, it would not be compliant with Article 28, that copying and paste what is in Article 28 is not compliant. So there is a clear necessity in the end of the day to insert the scenarios to get all these discussed, agreed, and in the agreement.
Absolutely. And so once you've done all of that, is that everything you need to be sharing in a privacy compliant way? So I think, no, this is an ongoing obligation to keep on top of that data sharing. As with all of privacy compliance, it doesn't end with the creation of the policy or the creation of the privacy notice, signing of the documents. The first point there, you have probably already achieved in the course of going through that level of granularity. You will have evidence and confidence the parties you're engaging with are capable of being GDPR compliant. But then you need to turn to your other documentation to make sure that any updates are necessary to privacy notices or records of processing, or if you have a broader internal data map, that they reflect any new arrangements. Over time, you need to monitor for changes, particularly, as Rocio was saying before, in areas where thinking is developing or parties are testing the waters to see what's possible. If the sharing changes in any way, that needs reflecting in the data sharing agreement, and you might even need to go back to your DPIA. It's a more fundamental change. And finally, thinking about auditing, as you would do in any processor arrangement, to decide over time what are the appropriate checks and balances to have in place to see that the other parties are doing what they said they would under your contract. So we're just going to pause there because that's the end of our piece on data sharing to see if we have any questions. And I can see there are some in the Q&A there, which we can look at now before we move on to international transfers. So I'm just looking down the list of questions. Rocio, were there any you wanted to pull out?
Well, there are some questions about model clauses that we will cover perhaps in the second half of this session.
So I take maybe the first one I can see about how prescriptive can two independent controllers be on each other in a data sharing arrangement. I think if you are independent controllers, that's one area where you have the maximum flexibility. So because GDPR doesn't require any minimum level of clauses or documentation, you don't have to be prescriptive at all, I think is the answer to the question. You might want to be more prescriptive as a risk management and protection from your own point of view, depending on the context of the relationship. So sometimes we have merely a sentence in an agreement between independent controllers saying, we are both controllers, we will comply with all our GDPR obligations. Sometimes you back that up with a mutual indemnity, depending on the risk that each party perceives of the other not complying with their obligations. Sometimes if there's a reputational impact, if one party is more of the public face of the relationship and they're concerned that if there's a breach by the other party, it'll be them who's impacted more, then we might have clauses requiring one party to notify the other if there is a breach, to share information so that that public response and image can be maintained and dealt with appropriately. So you really do have maximum flexibility in that scenario as to what needs to go in your data sharing agreement. I can see another question about AI. What effect do we think AI will have on all this data sharing? That's an area where Rocio and I have been doing a fair bit of work, because if what's prompted the question is, well, there's a lot of AI and that's quite complex, then absolutely. We've been working with our internal AI team on using personal data as training data instead of dummy sets and actual models, thinking about what you need to put in your privacy notices, because obviously transparency is not easy, and there are hundreds of pages of guidance from the ICO on explainability and how to put in your privacy notices what the impact of having AI used is on you as an individual. So I think AI will probably increase the amount of data sharing that we see and will make organizations want to be able to receive data, which obviously means somebody else needs to be able to give it to them. So I do think we will see more frameworks put in place to facilitate data sharing. The UK was at one stage looking at concepts like data custodians or data guardians, so sort of independent middlemen whose purpose is to hold data and ensure fair access to data, because fair access and competition and monopoly issues are increasingly arising as well, to ensure that companies have equal opportunities to innovate by having access to the underlying data.
There's a question about whether GDPR will still continue applying in the UK after 2022, because it's after the period of the extra year transition for trade imports and exports, etc. We think we will, because the GDPR is integrated now into UK law. And because the UK wants to facilitate the international transfer of data between countries, it aims to be adequate. So the GDPR regime is meant to stay in the UK as it is now, with some variations in future perhaps, but the essential rules, we will be extremely surprised if they are changed. So. And GDPR is now UK law, so we will explain that later as well, but yeah, it applies. There is another question about indemnities. That's something that Jocelyn and I discuss a lot, because we are waiting to have more case law to confirm how this will look at in specific scenarios. But all the things that Jos was saying about their setting up the responsibilities, being gradual in agreements, help to assess the level of responsibilities. We need to look at Article 82 and 83 of the GDPR and thinking of the fines what we see is that sometimes the regulator most likely will issue a fine against one party or the other, depending who is responsible for what. So it's probably there might be a narrow context in which one party can claim back that because they have been fined for what a processor did. Because if the regulator has decided that it is the controller, the one who was responsible, you can challenge that decision, but claiming back is going to be more difficult. So perhaps more relaxed on that way. In terms of claiming from compensations brought by data subjects, Article 82.4 also allows you to claim back for responsibilities if you end up, for example, if you are a joint controller and your supplier is a joint controller, and you end up paying for something that it was very clear that it was their responsibility, because to the data subjects, you will have the same responsibility. You will be jointly responsible and liable, but then you can claim back. So it depends very much on the context. Sometimes suppliers push back and it's not a concern or such a concern, so you can accept, or in other times, other circumstances, you really need to perhaps you want that indemnity and not being that cap because there is a joint control scenario. But that's why it is so important, all the points that Jos has been covering in terms of this level of detail, that it is, even if it is not mandatory, is recommended in data sharing.
Absolutely. I think, thank you for the questions. We will come back to some more at the end, but I think we should move on to the second part of the talk. So over to you, Rocio, for international transfers.
So like David Lowe said before, what we are covering here is just an overview of the mechanisms we have now in the UK, particularly after Brexit, when it comes into transfer data internationally. We are not going to have time to cover every single mechanism with detail. I'm seeing that there are more questions about model clauses, so Jos and I want to discuss model clauses a little bit more, but perhaps not with the whole level of granularity and detail that we will need a whole session or 2 sessions or maybe 3 for that. But of course, we welcome any questions after, and even we can follow up to respond other questions that are in writing that we don't have time to respond. Or like David said, just if you want more content and more detail, we can organize and arrange another webinar in that, covering just international transfers. So I'm not focusing on the questions that clients, or we have been discussing with clients. Jos, I think that the main question you could say is about Brexit, isn't it?
Exactly. The main question is, what do I need to think about in the context of international transfers now that the UK is no longer part of the EEA?
Yeah. So to keep that simple, because we've been advising clients from 2 years ago, getting ready to Brexit and thinking about international transfer, but the situation right now is as follows. So if we think about what happens when we receive data from another country to the UK, when that another country is a EEA country, now we are not part of the European Union. The main question or the main requirement to look at is the UK adequate? Now, the current position is that we are in the process of getting adequacy, and we are in a breach timeline that ends up, I mean, it's 4 months timeline that can be extended, and we expect is going to be extended until end of June. So during these 6 months, the transfer of data is allowed between the EEA country and the UK. So from the EEA country to the UK. And this process is not, I mean, we have had published, and you will see the draft adequacy decision by the European Commission, but this is in process. Like I said, we still need to complete 2 more steps. Second one is probably going to be challenging, but again, we expect to have it completed by end of June. But the second step, we are expecting to happen around April. The last step, we are expecting to happen by June, beginning of June. But because it's not guaranteed that this is going to happen, although we really, really expect that it's a high expectation that this will happen and we will be adequate, what the ICO is recommending is that keeping an eye on it, do your risk assessment, map your international transfers of data, identify what data you've got coming from the EEA to the UK that is high, in particular if it is high risk, and keep an eye on it and check what's the position by end of April. So if by end of April you are receiving news that, you are reading news that there has been some concerns, complications with the adequacy procedure, then you may need to start thinking of what other safeguards you may consider to put in place. Or if it is going well, maybe you can wait a month more or even until beginning of June to see the position, and hopefully we will be adequate by then. Fingers crossed, that's what we expect. So that's from the EEA to the UK.
I think we also increasingly are thinking about what about when we in the UK receive data from other parts of the world. Because as we work with our international offices, particularly in places like Dubai and China, Dubai have very recently passed a new data protection law. China's was not so long ago either. Increasingly, there are restrictions from those other countries about what they have to do when transferring data into the UK. So as part of the mapping that Rocio is talking about, we would encourage organisations to go and look back at their maps that flag where you receive data from other parts of the world, because their requirements are all changing too. Within other parts of the world, so Pan-Asia, they have an adequacy type area, just like there is over the EU. So there are developments there as well. But this is another area where we think organisations do need to be on top of understanding where is data coming to and from, because there are increasing numbers of international restrictions beyond what we're worrying about just post-Brexit.
Yeah, that's something I see a lot in my role here in your team, Jos, of lead lawyer of global data protection compliance project. And the tendency I see when we oversee over jurisdiction is that many countries that have implemented data protection legal regimes or are in the process of approving data protection legal regimes, they have some clauses, some articles stating that to transfer data out of their countries, there must be at least a similar level of protection. That's something I see a lot in many different jurisdictions. And there are countries like, for example, Brazil, that we were looking at the other day, that they have this similar level of protection as well. And then in addition, the new legislation is mirroring practically the GDPR, and it will have its own standard contractual clauses or codes of conduct and certificates that still to develop, but they are there, and the regulators are working on that. So we are coming into a context in which this is becoming relevant, looking at it globally, in particular on the high risk area. So don't panic. It's very difficult and it's a challenge to look country by country, all the jurisdictions when you are advising, when you are working for a global enterprise and you are responsible for compliance with data protection. But that's why it is so important to map these international transfers, to analyze the risk and to focus at least at the beginning on the high risk scenarios and high risk jurisdictions as well.
Absolutely. And I think also, just to add on to the end of that, we're aware that the US is looking at a pan-United States privacy law for the first time. So obviously California made headlines when they introduced their GDPR-esque legislation a few years ago, and we've seen that in privacy notices that we review and transfers. So if the US do that as a whole, that will be another big impact on international data flows. If we have to, just as we're now battling with Schrems, have to battle with data coming the other way into the UK from the US.
Yeah, and that is actually an important point if we move on to the other angle from which we can look at these international transfers, which is transfers of data out of the UK. What is the regime? What that is look right now? What are we discussing with clients now? One of the things is that, of course, the same mechanisms that you may know from the GDPR remains the same in terms of these are the mechanisms, but now they are going to be interpreted and applied by the UK government. So what we've got clarified by now is that any transfer of data from the UK to the EEA countries have been declared as adequate, as allowed. There are some territories included or expressly mentioned, just for the avoidance of doubt. For example, Gibraltar is still a territory to which you can transfer data without any other arrangements. To other countries, any country that is already granted with the adequacy decision by the European Commission is admitted, is not a restricted transfer, and it is admitted by the UK government as well. So quite similar at the moment on that sense. But then we've got that the UK government may, and we expect that they do, perhaps other adequacy decisions. We are going to have our own adequacy decision framework. And that's important to see, because there may be some countries that are not still or yet declared adequate by the European Commission, that the UK government takes the decision that actually we think that is an essentially equivalent regime and we declare it adequate, or perhaps with a little bit more flexibility, and of course focusing on maintaining the adequacy for us from the European Commission. So we will still want to be adequate to the European Commission's eyes, but the UK can indeed be a little bit more flexible. So that's something to watch out. And I wouldn't be surprised if in the next weeks we start seeing some developments from the UK government informing of how this will look, which is very exciting thing to see. Indeed, and from the with the transfers of data to the US as well, like you said, since there are a lot of development in the US, even for the SREMS 2 case, when the European Court of Justice ruled on the SREMS 2 case, it was considering how the regime was in 2016, because this is what it was asked for to be reviewed within the case. But if the legal regime is changing, even with regards to how intelligence access data, there might be more flexibility to consider how transferring data to the US would be adequate. So we'll see. But very interesting thing to watch. Hopefully, we will have a broader regime there, still being safe and essentially equivalent, of course. But if not, so we need to look at all the appropriate safeguards. And it's very important, I think, to consider, and I've seen some questions on that, how standard contractual clauses, European standard contractual clauses, will be applied now in the UK. So the first thing to consider, I would say, is that for the UK, to use the standard contractual clauses in the UK, it is allowed to amend the clauses only on the terms. As you know, you cannot amend any other thing. You can add content, but not amend. But you can change the names of the references to the directive, European directive, because this is standard contractual clauses, as you know, were approved under the previous directive and before GDPR, to mentioning and defining the UK GDPR, from lead supervisory authority or supervisory authority to the ICO, from European Commission to Secretary of State, and you can do that and convert it into UK standard contractual clauses until, if the government approve any standard contractual clauses for the UK, we have our own. But in any case, there is a question that we've been discussing with clients and kind of nightmare, you would say, so yours, in terms of the supplementary measures that you need to incorporate, if you need to the standard contractual clauses, if there is a risk, and this is us following this ruling on this SREMS 2 case.
Yeah. Absolutely, yes. It's obviously been a key concern for a lot of clients transferring data both to the US and to other countries. When transferring to the United States, part of the assessment that the court requires has actually been done for us in the SREMS 2 case. We know what legislation it is that the European Commission find does not offer essentially equivalent protection in the GDPR. The challenge, of course, is how to overcome that. So when advising clients, we have been looking much harder, I think, than we've ever looked before about other options for transferring data to see if there's different ways it could be done rather than using standard contractual clauses. And Rocio is going to look at some of those to remind us all of other options that are available. I think we've also been focusing a lot on the overall risk profile. Is there a way we can show or argue that actually this transfer is low risk? We might not be able to overcome the issues of the US legislation that's in place. It is what it is. But is there a reason that actually this can be done in a way that is de-risked or is just less risky in the first instance? I know, Rocio, you've been talking to people about some of the more practical measures as well around things like encryption.
Yeah, so when we were thinking of supplementary measures, in particular to transfer data to the United States, we found some challenges there because primarily we were only trying to keep transfers of data which we identify as low risk, so data that is less likely to cause a harm to individuals, like when you have a supplier and the only data transfer is email addresses, for example, or data that is highly unlikely, although that's something that the EDPB said, don't look at likelihood, but highly unlikely that it's going to be intercepted or of interest of intelligence in general, but in particular in the US. And then thinking of encrypting the data, for example, on-site and in transit. With the on-site encryption of data, we had some challenges as well. So it's not that easy. And we don't know what the UK government opinion will be in the extent to which these supplementary measures needs to be looked at. So, because definitely for high risk, when you have a high risk, you need to make sure that there is this essentially equivalent regime. And you may even need to stop that transfer and take a different view and a different approach if you can afford it, which is all the things that we've done as well with clients. That's storing the data in the EEA because migrating the data or stop sharing the data because it's much easier and they could afford it and it was doable in certain cases. So this is something that I think it requires much more clarification. And again, it's kind of, here are our recommendations. It's up to you. You need to do the assessment. You need to consider the risk. And if it is really low risk, we have been including these operational arrangements to the possible extent. And we think that this should suffice. But of course, there is still a lot of discussion on this point. So we'll see. Standard contractual classes, like we said, it is, we can talk forever about this and many different options, new model clauses, processor to sub-processor. We hope to cover that, some of this in the Q&A session. But let me just move on to very quickly, just reminding you of other mechanisms that are in the GDPR, that still remain in the UK. Binding corporate rules is something that it requires your attention if you are one of these organizations having binding corporate rules. The good news is that it is easier to amend binding corporate rules when they were approved under the previous directive, and most of the UK entities which have binding corporate rules had it under the previous directive, which is good. But in very short, if the UK is there is no mutual recognition, so you need UK binding corporate rules and EU binding corporate rules. So if you have binding corporate rules approved by the ICO, you now need to take steps to appoint a lead supervisory authority and to convert those ones into UK binding corporate rules. If you have binding corporate rules approved by an European lead supervisory authority, then you need to do the same. You need to kind of create a standalone binding corporate rules, telling the ICO these were approved by this lead supervisory authority and taking the steps to convert those one into UK. So that's a very short version.
And I think it would seem to us to make sense if you do need to go through that exercise, to do it sooner rather than later, before UK and EU laws diverge, which of course there is the possibility that could happen. So before you have to deal with those complexities, it would seem to be a good idea to start that process of getting your BCRs approved by either ICO or the EU, whichever is the one that you need to go to before any of those divergences occur.
Yeah. And definitely before June, before the end of June this year, that's the recommendation. You can find all the information that you need on the ICO's website. as to the steps you need to follow if your company has implemented by the corporate rule, or if they are in process of being implemented. You still need to look at this. And then just a quick reminder of we have other options still on process, but remains the same in the UK, now totally under the control of the UK government and ICO. And this will be codes of conduct, sector codes of conduct, and certifications under the approved certification scheme that the ICO is progressing, is still in progress. You can also have your own contractual clauses as long as you send it to the ICO and they approve them. So that's something that, for example, in Spain, we used to do a lot. It was mandatory anyway to inform of that, of that international arrangements. You send it to the regulator, they review it. If they're happy with it, makes sense, they should approve it. The same similar type of arrangement for public sector. And then we have other options for public sector in terms of this legally binding, enforceable instrument between different public authorities or bodies based in different countries. And of course, we've got the Article 49 exceptions, which you need to be careful because it's an exception, but it's still applicable if you have the context and you meet the requirements. So that's something that it is also recommended to look at. And that's all I think that we should cover today, and probably moving on to the questions.
Okay, so I've been looking up and down the questions. There are a few which I'll take together broadly about, do we need to go and update existing agreements that are already in place that refer to EU GDPR with the UK references? Yes, we have been carrying out that exercise. You should have a think about, do I still want to include references to EU GDPR and also introduce UK GDPR? Again, depending on your context. If you are two UK entities only dealing with personal data of people in the UK, that it would seem to make sense to confine your definitions to UK GDPR. But if you're a company where actually you might be selling goods and services over to the EU, then obviously the EU extraterritorial effect would apply, and you might want to think about retaining references to EU GDPR. But certainly, yes, we are making those distinctions in our agreements to be clear for everybody's sake about which legislation applies, because right now, doesn't make so much difference because we are on a par with the EU, but looking forwards, there is every possibility that different regulators, different governments might decide different things, particularly as Rocio was flagging, for example, around adequacy decisions for transferring data to other jurisdictions.
Positive. Now, other question that we actually discuss a lot with clients is the processor to sub-processor ongoing or data transfers. So when you have the controller exporter and the processor importer, and then the processor sends the data out as well to a sub-processor, we don't have currently in place approved processor to sub-processor clauses. You can agree on kind of a mandate from your controller that you are allowed to get into controller to processor for this sub-processor on behalf of the controller. When you have that approval agreed in a contract, we recommend that this is, with detail and the list of sub-processors is approved and so on, as with any processor for the international transfer as well. But the new draft model clauses by the European Commission that we hope to be approved soon are much more flexible, and indeed they have one model that allows or is meant to be put in place for transfers between processor exporter and sub-processor importer. So the processor would be able to put that arrangement with the sub-processor who is located in a third country. But at the moment, we are taking that approach as well, that for the processor to put in place model clauses on behalf of the controller with the sub-processor. We have considered other approaches, but that's the one that when you need to have in place these standard contractual clauses is what we are doing as well.
Yeah. I was just going to take a question on going back to data sharing briefly about is it advisable to put a data sharing agreement in an annex in contracts with clients? I think the most appropriate way to document your data sharing will depend on the context to some extent. If it's a services agreement, but it happens to be that you are both controllers, then it would seem logical to integrate it with the agreement to avoid some of those issues I mentioned earlier about conflicting termination clauses, liability, subcontracting, sub-processing, etc. In other instances, though, it makes that agreement either unwieldy or just due to admin, different teams and different organizations want to have their own document. So you then end up with a separate data sharing agreement. It's a little bit form over substance. There's no legal requirement for it to be standalone or integrated. It's very much whatever works well in your particular context. I wondered if you wanted to take one, it might be our last question, Rocio, about thinking about data subjects giving consent in relation to international transfers. We had a question asking about, should we look at that as a ground for international transfers?
It is allowed. It is in Article 49. I have to say, so far, practically all the context in which we have considered that option, we found out that it would not be fair, or it would be a total burden for the client to put it in place. But having said that, if you manage to be clear for the consent to be GDPR compliant, for the data subject to really understand all the risks and benefits as well, because you need, of course, you need to be commercial as well and convince them, but be very clear on all the risks associated to that transfer and the type of data that is involved, etc., then it's definitely one of the exceptions allowed. But in practice, I have to say that all the times that we have considered that, we haven't put it in place yet with any of our clients for the reasons I just flagged.
Right, I'm going to butt in now. We're coming up to 11:30 and I've committed that we'd finish this within an hour. I mean, we have been overwhelmed by your questions. I think we had more than 30 questions, and I think we dealt with about 10 of those. So sorry to those of you that we haven't got to. We will, after this, work out how we can respond to those of you we haven't come back to already. This session is going to be circulated to you all as a recorded version, so if you really want to watch, you can watch it again, or more importantly, perhaps share it with a colleague that you think would be interested. And also the slides will be available as well, so that you can review those and indeed share those as you want. I mentioned at the beginning that we're going to be running this poll as this comes to an end. I imagine Susie will be popping up shortly, asking what you think about a physical event in the autumn. Oh, there it is. And obviously also there'll be our usual request for feedback. Your feedback's really important to us in terms of what we cover in these sessions. We obviously want to do what you're interested in rather than what we're interested in. So do fill in the feedback form to tell us what you'd like to see done. I mean, it strikes me, for example, that having a opportunity to have more of a discussion and Q&A on data protection, many of the questions you've been raising of the day-to-day hassle of data protection compliance and advice would be an area, for example, and I'm sure there are other areas. Next week, we have Customs is on Tuesday, Customs International Trade post-Brexit. So for those of you who are trading across the UK-EU border, dealing with the challenges of exporting to Ireland and indeed transferring to Northern Ireland, the realities of that trade, that session will be on Tuesday. And then on Thursday, we have a session on human rights. You know, human rights is obviously something that we all as human beings think is important, but it's becoming more and more important legally for companies. If you or your subsidiary or your supplier fails to comply with some kind of human rights somewhere around the world, currently that's a reputational issue, but it's becoming more and more of a legal issue. We're going to be exploring that, discussing that next Thursday. So thank you very much. Fantastic how many of you hung on right to the end there, so I really appreciate that. And we'll end the seminar there. Thank you.
Thank you. Goodbye.
Goodbye.